Hi, I'm Sabine, the Purpose Lawyer. Thank you for listening. Please don't forget to like and subscribe to this podcast. It really goes a long way. It helps us spread the good word. And if you or anybody you know is in the market for legacy or estate planning or business or trademarks, please reach out to our firm. It's the Ambitious Legacy Firm. We are licensed in New York and New Jersey, but we have service partners in all states. So we'd love to work with you. Asset protection, legacy planning, trademarks. We got you. All right. So it's the ambitiouslegacyfirm.com. Now let's get into the episode. Welcome to another episode of the Ambitious Legacy Podcast. I'm your host, Sabine, the Purpose Lawyer. Thank you for listening and thank you for helping me be on purpose. So today I wanted to sort of get into a topic that is probably familiar to you. It is wills. And why do I want to talk about wills? Because there's a lot of sort of stuff in the media that's talking about wills. I don't know if it's still like a remnant of maybe, COVID and how things are just like still uncertain, but it's been on people's radar, right? Some people think you need one. Some people think I don't really need a will. If I could just like do beneficiaries, that's probably enough. Or I could just, transfer my deed, whatever it is. But we do need wills. Wills are important. Just because I tell you so much juicy information about trust doesn't mean that you don't need a will, because where there's a will, there's a way, right? Thank you for allowing me to give you some corny jokes. So let me tell you what a will is for those of you who are not familiar with it. So a will is basically a legal document that instructs the court on what to do with your assets if you were to pass away, right? That's just one of the best ways to sort of describe that, because you get to say within your will, whom do you want your assets to go to? Who do you want to be in charge of distributing your assets? And if your will is drafted properly, it will make it super easy for that person to be appointed and for the courts to follow your directions as to what you'd want to be done with your assets. And not only that, you get to help your family, your loved ones, your executor, who is the person who would be in charge. You basically get to help them figure it all out, right? Because you're going to list all of your assets and state where everything is and hopefully make it really clear as an attachment to your will. And that really takes a lot of stress away from the family, from the executors, and it makes it easier for the court to follow your directions, right? So if a will should be the basic planning document, like with every single plan, even if there's a trust, a will needs to be involved in the picture. Why? Because even if you have a trust, you want to make sure that if there's something that your trust didn't own, that was owned by you in your name, that your will be there to capture it and to direct it to its final destination, right? And so what's going to happen is when you create a will, you also get to decide that maybe if your next of kin by way of state law is not the individuals who you want to give your assets to, you can also include others that you love and care for, like your friends, your neighbor, your cousin, or whatever the case may be, your grandchildren. If you have surviving children, your grandchildren may not be a person that will not be a natural recipient of your estate, right? And so you can do these creative things when you have a will. And so I would recommend, well, this is not legal advice, right? But I typically would recommend that you have a will of your over your foundation, be part of your foundational planning, but also you need a will in place if you have young children, because the only way to really give guardianship over your young children is to have a will, right? So even if you have a trust that manages their assets for the long term and helps to protect them and things like that, you still want to have a will, because you need to say, like, who's going to care for your kids, right? Especially when you're as spouses, you travel and things like that. Like me and my husband, we travel together all the time, always in a car together. So if something happens to both of us, we have a will that basically says who's going to take care of our daughter. Because, like if you love your kid the way that I love mine, it's really important to us the type of life that she leads, right? And it's really important to us the values that are imparted into her and how she's nurtured and how she's spoken to, you know what I mean? Like different values for different people, right? Different strokes for different folks. That's another one of my corny jokes. And so, it's important to us that we sort of leave her with someone who has those values, someone who's going to speak life into her like we do. Someone's going to tell her that she's great and she could do, anything that she wants. And not only that, allow her the freedom to be herself, which is something else that's really important to us. So I'm sure everybody has some level of desire to see, their kids raised in a certain way. And so if you have a will and you decide whom that person is or whom those persons are, you'll be able to sort of help dictate that, right? Because what happens is if you do not leave that direction, then the courts have to say, okay, who looks like the best individual or individuals to raise this kid? Is it the individuals who stepped up? Is there anyone else in the family who's interested? And they're going to pick the best person, either the closest person who looks good on paper or, the best person who steps up who looks good on paper. And that may not be the person who you want raising your kids. Like I have people in my family who look good on paper, who don't necessarily have the same values as me and my husband do in terms of raising kids. And so we would not want our daughter to be raised by those members, because it's not going to be the outcome that we like. And I really take parenting super seriously in the sense that I'm blessed to only have one child, but I feel like that particular child is given to you because you have this certain set of skills or certain set of, your recipe of who you are and how you do things is going to really turn this child into who they're supposed to be. So I take that seriously. And so I'm really mindful about that thing. And so to have a court who doesn't have the information, doesn't have the ability to sort of understand like those family dynamics, those interpersonal relationships, they may look good. They may be a doctor, a lawyer, whatever, significantly successful person. And they may live in a 2-parent household and they may be a hot mess. Their relationship could be toxic and they could have a lot of issues within themselves that they haven't dealt with. And so now you have that child being put into that household, that environment, and the courts just don't know. They're doing their best, right? Or worst case scenario, they end up in I keep saying like protective custody, but like not protective custody, but with the state, whatever your state's department calls that, it's like, it's not an orphan. They're not, I guess they'd be an orphan at that point, but not an orphanage, but a foster home or something like that. That's what I'm trying to say. So we don't want that. We never want that to be the case for your kids, because you get to decide, you get to make a decision. So if your child's under the age of 18, they need a guardian. You need to have a will that says who that person's going to be. Another thing you could do with that, you can't necessarily with a will. Well, yes, you can. You can appoint someone to be a guardian over their finances versus their person, right? So you could say, I want this couple or this individual to be guardian over my children or my child. And they're great at nurturing, and they're going to give my child the quality of life that I want, especially since I'm leaving some funds behind. But they may not be the best person to manage funds because maybe that's just not their jam, right? So, but you have like this other great person who is good with finances and can make great financial decisions. That person could actually manage the funds, right? So this is good where maybe not like for spouses, but for, say you are not in a relationship with the parent, the other parent of the child. Something were to happen to you, you're okay with the other parent raising the child, which you don't really have a lot of say in, but the person is a good parent, you're cool with that. But you don't want to let them manage the funds. So you have a say in that, right? You can decide not to have that be the case. And also, Sometimes the courts can say that somebody, well, I kind of said that somebody doesn't look good on paper, but they might have been the person who you wanted. So if you plan, you get to override that. You get to say, no, court, I don't care how you think this person looks on paper. This is who I want to raise my child. And this other person can handle the funds if that's an issue. Or they could do all of it, right? So you get to really sort of design that, and you want to be able to design that. The other thing is, if you are a single parent, you have like a greater chance that your child can end up without a parent. So you have to basically, it's like just as much as you get health insurance for your child, or you take them to the dentist or whatever, you need to make sure that you have at least a will in place, right, to say who's going to care for that child, so that they don't end up without being in the right sort of environment. And again, that's one of the sort of basic things that you could do to basically protect your child. Another thing that you could do is to sort of help them, the person who is going to be caring for your child. You could leave like a little memo or a notarized letter that basically says like, hey, these are the values that I kind of want to instill in my child, because they may not necessarily know. These are the opportunities I want them to have. I think traveling is more important than education, or I think education is a must. Like that should be paramount. So whatever it is that you sort of would like. Another thing that I think is important is, because when a child loses a parent, has to be a super traumatic thing. I have not experienced that yet in my life, so grateful for that. But I'm sure it is extremely traumatic when I speak to clients who lost their parents. It's always very difficult. And so you may want to make sure that there are certain people who are important to your child, who are good for them, good to be in their lives. You may want to make sure that those people stay in their lives, right? Like make sure they still have play dates with this friend. Make sure that they get to spend some time with auntie so-and-so, make sure that, because if you leave them with like a friend, right, as the guardian, the friend may not know all the family members or all of the individuals in their life who you would want for them to continue to be in relationship with, right? So those are some things that you could do. Talk about maybe if they have health concerns, maybe if they have any sort of special thing that you need to dictate, you can also include those instructions. Another reason why you should have a will is if you have a child that has special needs. So children with special needs, it's a challenge and a very big responsibility to care for children with special needs. So if you have a child with special needs, you definitely want to have a will that's going to say who's going to actually care for this child, or because they typically have, and they don't have to be a minor, right? If someone has special needs, they may have those special needs or have those needs their entire life. And so you really need to have a will in place to talk about that transition. And so you could even talk, if there's not an individual who can take over, you could even select an institution or organization where they can be cared for. My mom worked in group homes and organizations for a number of years, and so I'm familiar with them. And there's some really awesome places that take really good care of people with special needs. There are places that are not so good. So you may want to be the one to sort of make that decision, so that you can make sure that that child or that individual is being cared for beyond your life, right? Another group that probably that needs to have a will or should have a will in place is those that are unmarried, right? So, well, unmarried and or maybe same sex or non-traditional, right? Not to be offensive, I hope I'm saying it proper. Non-traditional sort of relationships, right? So those couples need to, especially if, say, you raise the child together, but only one is the biological parent, you're going to need to have a will to basically say, okay, I want the other parent to get custody if they don't have custody already. You want to sort of put a will in place for that. And if you don't have any other planning document like a trust or what have you, your will needs to be there to basically give your assets to that unmarried person, that unmarried partner. because they're not going to, they have no rights, right? They're not going to naturally receive anything, and they could end up left with nothing if everything was in your name. I had a couple a few years ago that were same sex, and one of them passed away, and the family members made it very difficult for the survivor. They shut him out, hid all of the assets, or took whatever they could. They kicked him out of the apartment, the place where they were living. And luckily for him, he had, before he left the apartment, sort of like grabbed a bunch of stuff because he remembered his partner telling him where certain documents were. So he had quite a few things, and there were several life insurance policies left to him. Luckily, he was the beneficiary. But had he not had these papers, I'm talking about hundreds of thousands of dollars. Had he not had these papers, he would have never known. He wouldn't have known to go after it. So one good point there is that they had some conversations. Although he wasn't in the know about everything, they had some conversations. And so that's important as well. So that's really the will, right? That's the will scenario. I've talked so many times about whether that it's may not be the ideal scenario to just have a will, but these are scenarios where a will is really important. And even if your plan gets more complex than a will is still going to be part of the equation. So that's my story about will love. So now you guys could kind of talk about it. Each state has different requirements for signing a will and completing a will the proper way so that it could actually be followed in court. Because note that if a will is not done properly, if there's confusion about it, if there are questions that the courts may have, then the will may not be able to be proved in court, right? To be validated, okay, this was this person's actually last will and testament. So you want to make sure that if you are not working with a lawyer, that you dot your Q's and, dot your Q's. You cross your T's and dot your I's and make sure that everything is correct, or even get it reviewed by a lawyer if you did it on your own to make sure that it's actually going to work. Be mindful of your witnesses that you choose. Typically, you're going to need to get your will witnessed before you sign. And so be mindful of who you choose as your witnesses, because they may need to come in and validate that your will existed. And that's another good reason why you want to update your will, because if your witnesses passed away and things like that, you want to make sure that someone could actually be there to validate and say, yep, this was their will. Let's follow exactly what they wanted. So that's the story. Thank you so much for listening, and I will see you guys next time.